Bandit, the name of my dog, a 2-year-old boxer that we got about 2 months ago from the rescue shelter for boxers, recently needed some exercise. And to make a long story short, we took our dog to the dog park, something I didn't know existed before I got Bandit, and we let him run around. There were a number of dogs there. One of them was an Airedale Terrier, and I think the Airedale wanted to assert his dominance. Sort of reminds me of some lawyers that I've practiced against. Wanted to assert his dominance over Bandit. Well, if you know anything about boxers, generally speaking, from everything I've heard, they don't start fights, but they also don't back down. Reminds me a little bit of me when I was in practice. Didn't want to start a fight, but there was no way any of my clients were going to get raped in court. I would fight and do whatever I needed to do to protect my client. That's what Bandit did here. Well, the net result is that the Airedale and the boxer locked teeth. And as a consequence, the owner of the Airedale and myself sought to separate them. It was a difficult challenge, and in the process both dogs suffered some wounds, and the owner of the other dog suffered some wounds, and unfortunately so did I. I did something I knew I should not have done, and that is put my hand in the middle trying to separate two dogs. Well, it seems to me that there's a hell of a metaphor there, and the metaphor in effect is, are you, as a lawyer, a dominant lawyer? Are you seeking dominance for the benefit of your client? Are you seeking dominance because that's the only way you know how to practice? Are you seeking dominance, or are you seeking a reasonable and rational approach to protect your client under all the prescripts of the statutory codes? I remember being very frustrated with a number of adversaries while I was practicing who refused to take the time to review their case and really understand their case so that we could have meaningful settlement discussions. Discussions in advance of the hard preparation for trial. And when I came across somebody like that, I simply had to say to my client, look, this is going to cost you more money, but I have to prepare for trial, and there's no way I can bring the other party, the other lawyer, to the table to talk about settlement. A settlement that would be fair to both sides and accepted by both sides. That's what happened here. And oftentimes, I would come to the courthouse steps, and there would be a settlement negotiated exactly in accordance with what my understanding of the code was and what each party was entitled to under the code. The problem is that the client suffered by having to pay significant additional costs that would not have had to be paid had there been a settlement. Well, were the two dogs separated? Yes. Does that mean that one dog was dominant over the other? Not really. In the litigation context, do the parties ultimately separate? Yes. Do the parties ultimately go their own way? Yes. But what do we as lawyers do to help them preserve the limited assets that they have when they come to the table in controversy? What have we done to be part of the solution and not part of the problem? That's the question I leave for you today. Thanks for joining us.